era dominated by digital landscape where information is readily accessible, the concept of right to be forgotten has emerged as a crucial aspect of privacy protection. The right to control one's personal information and its online presence has sparked extensive debates, legal battles, and re-evaluation of the delicate balance between privacy rights and freedom of information. So, what is right to be forgotten? The right to be forgotten law is a legal concept that allows individuals to request the removal of their personal information from the internet. It is based on the idea that individuals have a right to privacy and control over their personal data. The law has been implemented in various forms in different countries, including the European Union, Argentina, and South Korea. So, what is right to be forgotten in the Indian context? The right to be forgotten falls under the purview of an individual's right to privacy, which is governed by the Personal Data Protection Bill that is yet to be passed by the Parliament. In 2017, the right to privacy was declared a fundamental right under Article 21 by the Supreme Court in its landmark verdict Puttaswamy case. The court said that at the time, the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 and as part of the freedom guaranteed by Part 3 of the Constitution. This is exactly what the Kerala High Court confronted recently in VYSAKH.K.G versus Union of India and other connected cases while deciding on a litany of 9 litigations. In all the cases, the parties claim infringement of their right to be forgotten under the right to privacy by uploading of a court orders or judgments on the India Kanun website, a free Indian law search engine that provides access to central laws, cases, constituent assembly debates, law commission reports. Among other issues, the court dealt with the question of whether publishers of judgments like India Kanun and other law journals have no right to publish the details of parties, ignoring the privacy rights of litigants, which includes their right to be forgotten. Answering the question in the negative, the court noted that reporting and publishing judgments are part of freedom of speech and expression, and that cannot be taken away lightly without the aid of the law. Interestingly, this is not the first judgment saying that the Madras High Court in Karthik Theodore versus Registrar General, which the present court also relied upon, and also noted that the right to be forgotten cannot exist in the sphere of administration of justice, particularly in the context of judgments delivered by the court. So, what are the criticisms of this law? Critics argue that the law undermines freedom of expression and public's right to access information. They also claim that the law is difficult to enforce and can lead to the censorship of legitimate information. Others argue that the law is too narrow in scope and does not provide adequate protection for individuals' privacy. Privacy must be added as a ground for reasonable restriction under Article 19(2) in order to effectuate the right to be forgotten. This will require a major constitutional amendment. On one hand, there must be a balance between the right to privacy and personal data protection as defined by Article 21 of the Constitution and internet users' freedom of information as defined by Article 19.